Okay, perfect. My name is Justine Sherman, and I'm so thrilled to have such a great turnout for this presentation because it's so important. We have tonight coming to us family members who are interested in learning more for their children. We have partner professionals, speech pathologists, people coming from school districts and from the regional center, and then lots of graduate students who are eager to learn about this process so they can come into the workforce really knowledgeable. And we have clients coming from Justine Sherman and Associates, as well as Mark Woodsmall's office. So welcome to everyone. Before we get started, I just wanted to tell you a little bit about myself, and then I'll hand it over to Mark. As I said, my name's Justine Sherman. I have been a speech pathologist for 25 years now, and I started my career in the school districts, and I worked there for 7 years, and then I became associate director of a private clinic, and then opened my own clinic in Sierra Madre, California, and that was 17 years ago. And now we have clinics in Monrovia and in Claremont, and I have over 20 amazing speech pathologists working with us. And we are a non-public agency, so we work with lots of school district children, and they come to us either directly from the district or after due process, which we may hear about today. And we are able to work directly with the IEP team and try and get the best services for your children. Our clinics work mainly with pediatrics, and we work with children with a variety of speech and language difficulties, from autism, cerebral palsy, Down syndrome, articulation, and then also with children with educational difficulties, and our educational specialist works with those kids. And if you have any questions throughout the presentation, please put it in the chat. And while Mark is speaking, I'll be monitoring that, or you can raise your hand on the, I think it's on the bottom, you can raise your hand and we'll get you at the end with questions. Okay, and I'm gonna hand it over to Mark now.
Thanks, Justine. I'm Mark Woodsmall, and I joined tonight by my colleague, Abigail Lombardo. We're part of a 7-attorney practice in the San Gabriel Valley area. We work all throughout California, especially post-pandemic. I think the running count currently of school districts where we've represented children is about 83. So it's amazing, just the scope of the need out there. And it's really an honor to work with the families directly, especially in this format. I think of all the things that we do as professionals in the field, I think opportunities to share information, to offer, these kinds of workshops where parents become empowered and sort of a teach you to fish mentality. I think it's really the work coming to fruition for Abigail and I and our colleagues. We can guide cases, but the end result really is an empowered family and a child who's learning and able to do a lot of what's been built for them, with support, but with emerging independence there. Justine and I have put on these talks. We were doing the quick math. It's been about 15 years, and it's a pretty fantastic legacy, I think, at this point. We found that putting on a multidisciplinary talk like this was really helpful for both parents and professionals because, obviously a related service professional like a speech-language pathologist in an IEP team meeting has a certain scope and an expectation in terms of the contribution and that kind of thing. And really what we were finding is that many of our experts, as we were comparing notes, et cetera, on the process, many of the experts were really looking for tools to more effectively advocate for the students in the meetings themselves. And I can tell you from an attorney's perspective in all of this, having a vetted referral, someone who's a high quality colleague who you can say, please go see them. They'll help you with this X speech issue or OT issue, et cetera. It's really, I think it's really wonderful to have colleagues who you can send that referral and not look back because that the child's in good hands. So Justine, thank you to you and all of your practitioners who've really just done such a tremendous job supporting the families over the years.
It's right back at you, and we are thrilled to be able to send referrals to you and know that they will be well taken care of in a respectful manner to them as well as to the IEP team. which is so important.
Okay. Well, with that, would it make sense to go ahead and launch into the talk? Just a quick couple of ground rules. If you can believe it, there are actually representatives potentially from 20 states tonight on the talk. And that's obviously pretty exciting because we're really talking at the end of the day about a federal law and a federal set of protections. Abigail and I are California attorneys, which means that we have a license to practice here in the state. And so you may find that some of the presentation that we're giving tonight is California specific, but where such elements exist, I'll try to point them out, and it'll give you a basis to seek that local guidance from maybe an attorney licensed in your jurisdiction, your area. Okay, so what we'd like to talk about tonight is really the foundations of the IEP team process, how to design a program for success, and also some tips and strategies, I think, for organizational empowerment for parents and providers. I will say that we try to make this process neutral. You won't see us talking tonight about X school district not doing a great job, et cetera. That's just not our philosophical approach to this process or the advocacy for the children we represent. You will hear that at least when we present and talk about IEP basics and rights, that really your best day in an IEP team meeting is one where your child's needs lead the narrative and conversation, and it should not be a battle of the egos. So you won't see a lot of that positioning or banging on the table from us. You will, however, hopefully receive some tools and supports that will help your meetings to become a little bit more effective and maybe a little less migraine inducing. So with that, let's go ahead and hop in. Okay, so whenever we're in the world of IEPs, there's really two acronyms that you have to understand because these two things drive the narrative for our kids. You are entitled as a parent of a child with special education eligibility to what's called a free and appropriate public education. This is called a FAPE. The second part of the analysis is really meant to be an anti-segregation component to the statute. It's born out of major and seminal cases like Brown versus Board of Education that you do not need to be separated in order to receive a proper educational benefit. So let's go ahead and jump into FAPE specific.
Actually, Mark, if I may chime in, I did want to give a bit of background before we jump into this. And this is just talking about understanding what the district needs to do and why. So I just want to briefly go over the federal and state standards. So your child's IEP, Individualized Education Program, is a legally binding document that outlines the specialized education and related services that they will receive in a public school. Under federal law, your IEP, is protected under federal law, specifically under the Individuals with Disabilities Education Act, or the IDEA. So this law ensures that students with disabilities receive a FAPE, a free and appropriate public education. Federal law sets the floor for what the district should be providing your students. It's a spending provision, which means that the federal government to participating states is providing some portion of funds towards educating our kids. And then the state is a cap or a ceiling. States can provide additional rights and protections to families and students, but they must comply with the federal floor in order to receive the federal funding. So that's just the quick background I wanted to give. Mark, if you have any other input there.
Sure, I think this is important for families that are operating outside of California and other jurisdictions. When we use the word jurisdiction, what we're talking about is a legal organization like a state or a sub-school district, a county, that kind of thing. But as to Abigail's point, if you consider that the federal law creates the basic minimum of what a school district has to do if that state has elected to receive funds, and we pretty much have 49 states that have done that, with the exception of the state of Utah, which runs things exclusively through state law. Once you understand that this is the basic floor of opportunity, the standards of FAPE are really applicable to all of the states that have accepted the federal funding. But of course, the states can then expand the rights of their families, and that's why it's important that some of what we share today is going to be general application and specifically tailored to California, but there may be opportunities where your particular state has expanded the rights or raised the ceiling on those rights. And it's important for you to seek that local authority to advise you on specific carve-outs that may be applicable to your state or region. Okay. So when we talk about FAPE, I think, quite honestly, I think a lot of families are expected to sort of wander into this process and immediately know what that means. If you're newer to the process, one of the first things you probably have observed is that special education is replete with acronyms. Not all of them are obvious, and sometimes we have multiple acronyms for the same concept, depending on what school district you're in. So what I would suggest is probably one of the best things you could do for yourself early on is locate an acronym set of common special education terms and the initials that stand for those things so that you can start to navigate and feel a little bit more comfortable. When you talk about FAPE, it seems like a quite obvious standard. If your child needs special education, it should be free to you, which means you shouldn't have to fund it, you shouldn't have to subsidize it. It should be the program that you require, and then you shouldn't have to pay for it. The word appropriate, I'd like to kind of put that on hold for a minute because this is really where all of the analysis comes in. And public education is really just the delimiter that says the school district that you moved into, maybe for the schools in the beginning, is the organization that's responsible for providing the supports and services. There are some exceptions to that. For instance, some charters that aren't linked to a brick and mortar or don't necessarily speak or educate to a specific community, but rather invite children within its programming. These are also public education institutions, or LEAs, under the definition of the law. Now, simply put, the law says that your child's entitled to a FAPE, which includes placement and services in conformity with whatever your IEP team document requires. Now, the IEP, for all intents and purposes, is really a contract, and the contract is the district's commitment to you and your family regarding the manner in which your child will be educated, how you will be communicated with, et cetera, about the progress. Now, then you get into the concept of appropriate, and appropriate is where really Abigail and I do most of our work. And that is that in order for a program to be appropriate, it has to comply with the procedural requirements of the law, and it has to result in a substantive something. And I know that seems legalese. So the way I've tried to come up with an explanation over the years is kind of using the analogy of the quiet country road. Now, if you're driving down the quiet country road and off to the right-hand side is a nice stop sign, you run through the stop sign. That's a procedural violation, but if you're the only car on the road, no one saw that you ran the stop sign, that's a procedural violation that exists all by itself. It's against the law technically, but what happened as a result of you breaking the rule? Not a whole lot. The substantive element would be what happens when you break the procedural rule. So let's say you're driving down the same road and you run the stop sign, and this time, rather than just running the stop sign, you've collided with another vehicle. Now, the procedural violation in that instance results in a substantive something, harm. If a school district violates the procedural rules of the road and it results in harm to the child, this is when possibly FAPE is denied. It's important, though, because when parents are navigating this process initially, they're taught about all of the procedural safeguards and rules. For instance, we have a rule that says that within 30 days' time of a parent request, you are entitled to an IEP team meeting. Let's say that parent makes the request. The meeting is held on the 31st day. Now, technically, it's a violation of the rule, but it's really only 1 day late, and it's kind of like running that stop sign with nothing happening. Let's say, similar analogy, parent makes the request, the district is holding the IEP team meeting on the 35th day. But in the span of time between the 30 days and the 35th day, your child was denied the ability to participate in a school-related field trip because they couldn't get the necessary accommodations and protections they need to be successful. That's an example of where the procedure marries with the substantive denial, and then there's a problem. Now, this works the exact opposite and in the positive as well. When the school district follows the procedural rules of the road and it results in an IEP that's calculated to confer educational benefit, then the district followed the rules, and the substantive something is that the child made meaningful educational benefit against his or her related goals and objectives. When that's happening, your child's receiving a FAPE and you're in a good spot. And I think it's important for families to understand this distinction between these terms, because technically you have to understand when the violations are arising and the effect that that has ultimately on your child's program. Let's go to the next one. Now, I think it's important for us to clarify that when we look at the court's definition of what is a FAPE, we really go back to really well-established rulings associated with, and we're talking about interpretations that go back to the early 80s. We have the Rowley versus Board of Education case, and this is really the sort of the grandmother of special education cases. It talks about the basic rights, and essentially Rowley stood for the proposition that school districts provide FAPE when a child receives educational benefit. And pretty much that was it. And the question was, what is educational benefit? And how do we really know what it means? And we pretty much had this vague standard all the way up until very recently, when we started to define what substantive benefit really means. And I think if we go over to, do we have, Abigail, do we have an Andrew slide, or is that one referenced only there on the left side?
It's referenced here in this slide. So.
Okay, so Andrew F. Was the Supreme Court's interpretation of the Rowley standard, and in Andrew, the Supreme Court said, look, having de minimis value, some kind of very limited benefit is really not the intent of Congress and wasn't what the act was intended to mean. We wanted to instead have a meaningful educational benefit that results in basically gauged in relation to the potential of the child at issue, which is if the child's capable of accessing a greater educational benefit, we certainly would want to see them have that opportunity and benefit from their educational programming. In the Ninth Circuit, this standard was further expanded in the Antelope Valley Union case. And there, the Ninth Circuit said, look, how do we gauge what is it that we're striving for? And in Antelope Valley, the conclusion was, look, we would want to start with the idea of helping the child move from where they are at initial assessment all the way through where they should be, gauged in relation to their same age peers, their neurotypical colleagues. And so we would want to move towards the standard of passing grades within the general education curriculum. I think this is an important distinction to raise, because I think if you take anything else from this talk, it is the concept that we really don't have even 1 year to lose. Your child's program has to be aggressive, challenging. We have to set the standard high, and we have to strive to help our children to get there. And I think it's especially important that we aren't just phoning it in on a given year and having some kind of benefit, but really not the kind of benefit that we can take home and say, this was a great year for education for our child. Okay.
And if I may, Mark, I think that's the perfect piece of by what it used to be, right? Some educational benefit, okay. That's vaguely defined, but part of, your participation in a student's IEP as well is taking that aggressive, stance and wanting to give them a program that is challenging. They're not just getting some benefit, they are being challenged in school, they're learning, they're working their brains, all of that. So just having a strong standard and advocating for that, because it can be easy, or it can happen where you're presented with information and it sounds like that's progress, but there's more pieces to that puzzle. So I'll move on.
Yeah, it's very good. We'll be talking about making goals measurable and how to track these items as well. Certainly in the rest of the talk. Okay, so least restrictive environment. I think this is a complicated but rather simple approach to things. And the concern that I see most frequently in IEP team meetings around restrictiveness is that many school teams have different definitions for what it actually means. As I've thought about how to present this to the parent and professional community over the years, it occurs to me that really the word restrictive could be substituted with the word segregated. And I think that it becomes immediately apparent what was intended, which is your child is entitled to be educated alongside their peers in the least segregated environment. And what that essentially means is we would want, wherever possible, to start with a continuum of placement options that every IEP team should begin with, where would my child be placed, but for the fact that they have this disability that's affecting their educational acquisition. So we start with the general education classrooms in their home school. And before we can remove that child to a more segregated or restrictive setting, or the degree of removal from other children, we have to first show that aid supports and services couldn't first be brought to bear to help them to succeed. Now, sometimes this restrictiveness issue comes up in the context of aids themselves. And I hear sometimes parents are told, well, we'd love to provide you with an aid, but we can't because that would be too restrictive for your child. Now, what the school district might be trying to say is that, that could cause a barrier between them and their peers, and that would be pulling them away from the general education milieu. However, the question I think that parents and team members need to ask is the aid's function in that instance a byproduct of the aid's lack of training, or is it that truly having an aid there at all causes some sort of segregating benefit or penalty? This LRE concept applies to services as well, which is sometimes parents may have the view that they would like to have clinical services for their child. And the school district's response might be, well, if we would love to provide you with those clinical services, but that would be too segregating or too restrictive for that child. But you have to look at how it all falls out, because sometimes a child receiving services in a clinic opens up opportunities for that same child to participate in the general education environment throughout the entirety of their school day. Justine, we run into this issue a lot, don't we, on the need and the efficacy of clinic-based services or individual services versus group? I mean, how do you see it coming up in your meetings?
Well, often in the meetings that we attend, we talk about, and we'll talk about this in the future, the goals and the need for services, and if those goals can be obtained within a group setting, how much time a child would get actual attention within that group setting, depending on how many kids are in. When I was in the schools, and it was so many years ago, they didn't even have caps on the amount of kids we could see. I had 85 kids on my caseload. So I had, 7 kids in a group, which really ended up being about 5 minutes per child that I could actually do services with. So we talk about that, or we talk about if their services are so extensive that they need to be pulled out of class so often, would it be better for them to be in a non-public agency so they're able to attend the classroom and really get the benefit without being removed multiple times per week.
Absolutely. I would want to also alert everyone today to an updated opinion on LRE. This comes from also the Ninth Circuit. It's a December 2022 case, and it's known as DR versus Redondo Beach. What I want you to know about this particular case is that the proposition advanced by this case is that a child is entitled to be educated in the least restrictive environment, even if segregating the child and placing them in a more restrictive environment might result in greater educational benefit. The court had said where the preference is for inclusion, a school system may not segregate a child just because it could do a better job. Now, keep in mind that, like I'm sure you're picking up by now in this talk and probably in your experience in special education generally, cases work both directions. So if you're needing to make the argument, for instance, clinic versus group-based services, usually something like I might approach from the perspective of the child needs clinic services first to establish foundational skills. And then once those skills are foundationally established, then we would look to generalize those to other settings through a group. And so, that would be the distinction, I think, between inclusion first and segregation thereafter, even if it results in a greater benefit, to the distinction of, but for the clinic-based services, the child would not achieve the foundational proficiency to even be successful in the group-based session. And so what I would want you to be thinking about is how these concepts of segregation and restrictiveness apply, and how, like most law, things can be interpreted in different directions, for the same proposition. Okay, let's go ahead and move to the next one. Abigail, you wanna take up the DIS concept?
Right, so it's following along with what we were just talking about. It's talking about related services and what supports does your student need to benefit from the special education that's being provided as documented in the IEP. Related services, there's a non-exhaustive list in the law. It can be in Justine's realm, it could be educational therapy. The list is massive. Occupational therapy, visual impairment support. But those services are determined by an IEP team to support your student in their learning, in accessing and benefiting, separate, but I like to think of them as the same thing. Like, can they access their instruction? Meaning, are they intaking what your teacher is saying? Is it getting through into their brains? And then also, are they benefiting from it? Is it appropriately challenging for them? Is the grade level, I like to think, challenging. So related services go to support your child's learning. Benefit has been determined to mean making meaningful progress towards meeting objectives. So as with FAPE, which is conferring meaningful benefit gauged in relation to the potential of the student, what that benefit looks like is, are they achieving the goals and objectives developed by the IEP team? That's why we spend the time doing assessments, preparing these goals. They're individualized, they're based on this student. And if a student isn't reaching those objectives of goals, we ask, why are they benefiting from this educational plan that we've put together for them? So that leads us into our next steps, which is kind of the step-by-step in the IEP process. So I'm going to move forward unless Justine or Mark had any input.
I think the maybe just one more takeaway on this has to do with the fact that I know certain school systems do things a certain way, and there are some services that that maybe they feel are more generic and appropriate than others. But I think the San Diego decision stands for a very broad proposition, which is if there's benefit, then it's an appropriate thing. And I think that that really opens the door to a range of research-based and peer-reviewed interventions that have efficacy for helping our kids. So I think the takeaway is really just think broadly, and once you've identified something you feel is appropriate for your child, look for the research base and then try to figure out ways that we can build an advocacy approach to get that into the document.
Right, and I think once we get more into the goals, that broadness as to what we're talking about and what services can help support that progress becomes a bit more clear. You know, it's not solely academic in nature, for example. It can be broad. So,
okay, let's talk about sort of action steps to get ready. Now, in person, if we were having this talk, right about now, I'd ask you, okay, how many of you are here with a child who's in the 3 to 5 range, middle school, et cetera? I will tell you that these principles apply all the way from 3 all the way through 22 or graduation, whichever comes first. These are always going to be sound principles that you could use and essentially bring to the IEP team table for success. When you're getting ready to come into an annualized meeting, I think one of the things you have to consider is what do the documents suggest about your child's needs and what would they benefit from. If you've engaged with the regional center, for instance, in your 0 to 3, or perhaps you've hired a specialist who works with your family on the outside of the school day, consider asking that therapist or that provider to reduce their recommendations to writing. Better yet, if they're available to come to the meeting, invite them. But you certainly would want to have your private providers have the opportunity to come in and share what they know about your child's unique needs. If the district has conducted testing and evaluations, I would really recommend that you develop a mechanism to receive those draft documents in advance of the IEP team meeting so that you have the opportunity to review them and understand them. Maybe you can take the material and share it with a private provider and say, this is what the school team is recommending. What do you think? And then finally, don't put yourself out of the analysis, which is parents, you know, I think we have to reclaim our power in this process, which is that you've been with the child since the child came into this earth, into this world. And there's a lot that you know and a lot of wisdom that you can bring to the table. I find that when parents solidify their understanding of the child's needs, if they have very specific notes and observations that are date delimited, time delimited, explain the skills a child has or difficulties a child has, that this gives you a position of information to operate from with the IEP team. And I think that it generally creates a level of trust and collaborative spirit in the meeting itself. Okay, let's go to the next one. So let's talk about IEEs and the evaluation process. Special education is driven by needs analysis and strengths analysis. And the way you get there is through comprehensive and thorough evaluations. Evaluations lead the process. They determine what the child might be eligible for special education, under what category, et cetera, and also the areas of concern. Traditionally, if you're starting out the process and you're concerned that your child has educational needs and they need the support of special education, you can call for an assessment. And the assessment could be in a range of needs as your child's presenting them. It used to be that the family was limited in the number of assessments that could be requested. Traditionally, there's the intersection with the concept of the triennial, and many people feel or have been told that you really only can ask for assessment for your child once every 3 years. I think it's important to clarify that a triennial evaluation is a statement in the law of the minimum interval that the child that should exist for the child before comprehensive reassessment is conducted. Many parents report to us that they're told that they ask for an evaluation, but the school team will respond, Well, why don't we hold off on doing the testing till the triennial, which is coming next spring, and then we can go ahead and do it at that time. The concern, of course, is if you're asking, let's say, for an assessment now and you end up waiting for the spring, you've essentially waited the lion's share of the school year for an assessment that would help you and the team determine what's most appropriate for your child. So I want to clarify that after IGA 2004 is implemented by the regulations in 2006, parents are now entitled to an assessment one time per year, if you wish. You may want to slow that process down because I know assessments aren't the easiest for kids, but you should know the rights that you have. Now, when you ask for an assessment, the district should respond within 15 days with an assessment plan. Now, what the assessment plan is the district's vision on how to assess in the areas of need that you've raised. And it's meant to be an invitation to the parents to the assessment process. You are not obligated to sign and just approve of all the assessments. You have the right to engage with the team and expand or restrict the assessment plan as you believe appropriate. And if there's disagreement about that process, there's a process for that that exists called prior written notice, where the school system can tell you why it feels it needs the additional assessment or why it doesn't want to assess in the areas that you're requesting. But that's a formal process, and it comes with its own slate of rights. And I want you to understand that parents, when you're being asked to navigate this process, you're being asked to navigate an assessment process that's really meant to be a team collaborative process. So if you're finding that you've been excluded from the process and you aren't able to get the answers that you need, there are protections for this. Once the assessment plan is signed, you generally have 60 days, less breaks longer than 5 days, so it's important for you all to know we're coming up on the holiday break soon, and that's going to be a break longer than 5 days. That puts a hold on the 60-day timeline. So you would want to be aware that what your timeline looks like as you're planning the programming. I would say it's always a good idea to put your requests in writing. Writing is important for folks like Abigail and I to see when the parents made the requests and to see if the school district is following the procedural timelines that would ultimately result in procedural compliance with the law. Remember the stop sign a moment ago. If the school district assesses on time and the assessment is comprehensive, that's a representative effort towards FAPE. If the school system is delayed in their assessments or the assessments are not comprehensive, that would be a good example of where procedural and substantive violations might be rising, if it makes sense. And I think one more thing on this, when you put anything in writing, I want to stress the concept of the permanence of the written word. I don't believe that as parents, we enjoy the luxury of losing it in writing. And what I mean by that is, I think the tone that the team greets the family with is often born out of how the family itself approaches the process. And so even if you're frustrated, even if you feel like some of your needs or concerns have not been addressed adequately, I would always say we should always lead with courtesy and the opportunity with the olive branch for collaboration. I know it's not always going to be successful, and I understand that there are other tools that may be needed to address situations where the family is not being engaged in the process, but I never would want to see a situation where the parent could be blamed for the child not getting the help they needed because somehow they were just so very difficult to work with. And believe me, the judges that hear these cases and consider the parents and the school district's positioning in these cases, they're humans and they look at conduct. And so it's important that at all times, I say, we represent ourselves and the child in the most positive possible light to build that opportunity for success. Okay, let's go to the next one. I think we should be talking about evaluations, and more specifically, Abigail, maybe you could cover child find and we could talk about this slide, and maybe I can add some additional things if it's helpful.
Okay. Child find refers to the district's obligation to find all children with disabilities in their jurisdiction, within their district. Those are students or children who are in need of special education and services. And what this means is, if your district, let's say you're already in school and your student starts to present with some struggles in reading, or there's some sort of speech related, concern that they're noticing. What we're looking for are triggers of lacking information almost. Hey, I'm seeing to identify or suspect that there may be some need for this student. In order to better understand that, we need more information. That is a child find trigger. You need to find the student. You need to evaluate those concerns, those suspected disabilities. And then from there, make a determination as to whether IEP support is necessary. Now, that does broaden to all students within the jurisdiction. When we get outside of students in the public school system, there are similar but slightly different rules, but the obligation still exists nevertheless. If you are located within the district, that's what the child find obligation refers to.
If I may, this is an opportunity, I think, where we would look at things like, Justine, if you're seeing a child in your clinic, maybe 0 to 3, and they're getting ready to launch into the school system, what would you say would be the importance of your testing in relation to this concept of child find and then forming the basis of goals and present levels?
Well, often for, say, children that we're seeing through the regional center, which is we see them the birth to 3, our exit reports will indicate any areas of need that we're continuing to see, and recommendations will indicate that we're requesting formal assessment through the local school district. So we are the trigger to get more services, at least, and we speak with the parents to indicate it's time to call the district and request services, or at least testing.
I like the concept also that when you've got a professional who's done a workup for your child and really understands the child in therapy and their progress, this really provides a really excellent basic understanding of the child's unique needs, which then gives rise to how the assessments ultimately give way to, present levels of performance, which is the starting place of a goal, and ultimately the annual expectation of where they go. One final point, I think, just has to do with the Forest Grove decision, Supreme Court decision 2009. And in Forest Grove, there was an analysis about the concern that Congress had that the assessments be thorough and complete. Where I see this most frequently come up for families is in situations where the family has a range of needs, maybe concerns with emotional regulation, with specific learning disability concerns, maybe the child's onboarding information at a rate that really isn't keeping up with their peers or isn't going to be able to keep up with grade level expectation. Be wary of any situation where the school district says, I understand that your child has all these needs, but let's start first with this assessment and see from there if we need to do further testing. I think it's really important that we try to do this in a single pass in a way that's sensitive for the child. But the key is when we assemble the IEP team, we don't want to be at the table without necessary information to develop a plan for a whole year. And I think the idea and concept of a rolling assessment process is pretty exhausting for the child, for the parents, for everyone, really. So, when you get into this concept of thorough and complete, I would generally say you have to assess for every area of suspected need. And if you don't do that, then you can count on the fact that you probably won't have the data you need for goals in all areas of identified need. And so that then compromises the total analysis for the year, because now you're sort of onboarding goals in a running fashion, which is really just not an efficient way to build a program for a child or to measure progress and efficacy of the services provided. Okay, let's jump to the next one. Very quickly, the role of the independent evaluation I think in special education, there's really two kinds of IEEs. One is the parent secured IEE, which is an independent expert's view that says that this is what the child's needs are and this is what is recommended. Parents can obtain a right, they have the right to obtain an IE at any time at their expense, of course. But there are no limits or boundaries on that, as long as that assessment is conducted by a person who's qualified to do the testing. In other words, you wouldn't want to have an education specialist doing a speech-language pathology report, something like that. But once that IEE is submitted to the IEP team, the team needs to treat that assessment and the assessor with the same weight and regard as it would give district counterparts. Now, it's easy to say you can go out and get all of these second opinions, but let's be realistic. It can be expensive, and sometimes these outside assessments have limitations. The most glaring limitation that comes to my mind would be educational implications of the testing. And what I'm looking at there is sometimes parents are told, look, your child could benefit from, let's say, a neuropsych assessment. A neuropsychological assessment is one of those assessments that's available for families to help them better understand how the child is onboarding or demonstrating knowledge, how the memory might be functioning, issues associated with executive functioning, brain-body connection concerns, issues associated with state of arousal or regulation. These are all things that a neuropsych can really help with globally. But if you get something like that through your medical insurance and the neuropsych never sees the child at school, there are problems and concerns with that, because then this is maybe a finding that's highly relevant for the child's developmental health, but it doesn't necessarily speak to their progress within the educational setting. Let's go to the next slide and we'll talk about basically how we use the information now. When you think about a goal, I want you to think about really thinking about a goal in component parts. I sometimes refer to goals like an annualized analysis, almost like a one-year marathon. And like a race, it starts with a starting line, the present level of performance. Then we measure how the child's progressing against that annual expectation. And then finally, we need a finish line or a method of measure so that we can see how the child did. Now, special education rises and falls on progress against goals. And I think it's really important that you have goals that can be objectively measured by data that's objectively presented. And I'm thinking about, there are some cases that reference this concept called the stranger test. And when you hear it, especially in the context of children, you say, well, that sounds really menacing. It really speaks to this concept of, could a stranger pick up your child's IEP and ultimately read and see if the child's objectively meeting the goal? And you should be able to know without any kind of slant or extra information whether or not the expectations of that annual goal are being met or not. And I would say that insisting on measurable data that's objectively recorded really gives you a shot at having a child-centered IEP, because much of this process turns on family feeling comfortable with what's going on in the school setting and having a level of trust. And I would say that the educators also feel frustrated or concerned when the family doesn't demonstrate the trust to them, which is, we're working every day for your child, you got to trust us, take our word for it. I say, if the data is being recorded objectively, everyone can assume the teacher's working as hard as possible. Everyone can assume the parents are doing their very best. But at the end of the day, we're measuring whether the child's making meaningful educational benefit or progress against their goals. And it's really not about whether the teacher is a great teacher or whether the parents are X. It's about what the child is able to do. And I think it's that insistence on objective measurability that gives us the freedom to sort of move away from those struggles that lead to breakdowns in relationships or those frustrating IEPT meetings that we've either heard about or been part of. Let's go to the next one. Okay, let's talk a little bit about the goal matrix. Basically, what we created the goal matrix as a mechanism for parents to be able to have a way to keep track of this process. When you get into the IEPT meeting, there's a few things I think you can count on. You're probably going to be stressed. Many parents, even though both parents are 100% there for the child, sometimes they have arguments or frustrated discussions about progress. And it comes down to that. I think parents carry the weight of the world on their shoulders to make sure that they do 100% of what they can for their children. And it comes with a lot of pressure because society expects that the parents are going to help that child to become as capable as they can be and navigate their educational system to the goal of successful graduation or independent launch into the world. And that's being a good parent. And the school system expects it of the parents, and the parents obviously would want to see their child get there. The problem is when you're sitting in the meeting and you've got 8 or 10 professionals who are delivering messages to you all at once of all these different subdomains of the child's unique needs, how do you keep track of it all? So let's show you how the goal matrix is set up, and then we can talk about how to fill it in. So what I imagine is you've got an 8.5 by 11 sheet of paper, and you sort of lay it out in landscape wise, and you draw lines. And for each area of need that your child has, and I think you get these both from your own knowledge of the child, but also from the assessments that you've hopefully reviewed before you even went into the meeting. This would be private sector assessments. These would be the school district's assessments. These would then give you areas of concern. And those areas of concern you could label by generic titles, like example here, pragmatic language or behavioral inattention or concern. Then you can go to the present level of performance, because usually the assessment will talk about what the child was presenting during the assessments. You could also look at the last year's IEP as a source of information and talk about, according to the last year's teacher, which had a really great rapport with the child, this is what the child was able to do. So by example, the child can currently engage in 3 conversational turns with a peer with 1 verbal prompt. So that gives you a success measure, and it also gives you a prompting support measure in terms of what's necessary for the child to be successful. Now, I recommend that when you have this goal matrix, that you put a reference to where you found the information, so that when you're in the meeting and the press and stress of what comes with being a participant in such a meeting as a layperson, often, you're going to be fumbling through your paperwork and you're not going to remember where you read that thing, or you're not sure where to find it. But if you give yourself a reference, right, the private speech and language pathology report, page 3, that gives you a chance to go back to your highlighted note and make sure that it's shared and put into the notes. As the need is addressed by the school team, you can leave the IEP goal number blank and write it in as you get there. And the reason is that when you are in the meeting after the fact, you come home, you have the document. Now you can then combine your goal matrix that you assembled, your organizational document, with what the school team has done in the IEP, and you can compare them. And you can say, did every area of need that my child had get addressed in this document? And if not, what do I need to do to, after the fact, add additional information to make sure that I've got a child's IEP that really addresses everything? Now, if you have notes throughout the meeting, you've all experienced this. If you have concerns about what's being said, you could immediately stop the meeting, raise your concern, spend a fair amount of time going through that, have differing opinions. Maybe not everyone who's needed for that is even in the meeting at that moment. And this kind of thing could take hours and hours and hours. On the other hand, wouldn't it be convenient if you had notes that specifically raised your areas of concern? And when the IEP team asks you, what do you think about this goal, or how would you like to change it? You could say, I really would like the opportunity to really digest what's been presented, take this home, and in a time and place when I can really concentrate, review the material, and I'd like to get back to you. What we recommend for our families is that after the IEP team meeting, they create a parent addendum or statement, and that talks about the areas of the IEP that they agree with and will authorize. It also says the areas maybe they don't agree with, or maybe they have concerns with, or additional areas where assessment is required, etc. And this one document in one place allows the parent to express their concerns in a very business-like and very organized fashion. And it allows you to make good decisions when you're rested, not exhausted, not overly stressed, and when you can look at all the materials after the fact in an organized fashion. Goal matrix. Okay, by the way, you won't find that in the law anywhere. It's not like parents are entitled to a goal matrix. This is something that we've created to help parents take all of this huge amount of information and bring it into a concept that you can take that information and use it for your child instead of getting buried in it. Now, these are some simple common goal concerns. I'm sure, Abigail, you and I have seen these in our work day to day. Just to quickly go through the list, no goal means no need. School districts are obligated to write goals and objectives in every area of need. If you have an area of need for your child and the school district says things like, well, we're not going to write a goal because our classroom already works on that, and so we're covering that. That's when you would want to say, in the calmest possible way, I understand that perhaps the child's classroom already has that support, but if we write a goal, we can measure if the child's lending to the support or not. And that's how we measure the unique child in that setting. Beyond that, there's a concept here called portability of IEP goals. And that is that what might be going on in this particular one classroom needs to be able to be picked up and brought over and dropped into a new school system so that they understand what it is that the team is working on. So it's not adequate to say that it's already going to be addressed and we don't have to write a goal, because that really is telling you there won't be a need that we're working on. And certainly not something you can track and measure with objective data. Now, goals have to be based on clear present levels of performance. And it goes back to that assessment slide and what we were talking about, having a really good gathering of information, private sector, public school assessments, your own notes. These should set the starting place for a one-year analysis, because if you aren't measuring for a year at a time, you're denying your child the chance to have a year's growth at a time. I would say that goals should always be written in the context of the curriculum. There are often goals that children have developmentally, things they need to do in the community, et cetera. Keep in mind, if you're raising these concerns, but there's no nexus or link to the educational setting, you're setting yourself up for the sort of response from the school system of, we understand that's an area of need your child has, but that's more medical or that's community-based, that's not educational in nature. And I think if you think about it, most of the time, the things that you're raising in the IEP team will have an educational connection. You just have to think about what it is. Is your child able to demonstrate sportsmanship? Or are they able to interpret the gestures and actions of others? And you may feel like, well, in church, they go to Sunday school and they have a difficult time, or they're in temple and these are the difficulties, right? But if you think about it, the application to the educational setting could be as easy as a science group, or playing in a game on recess, so in other words, you can take a concept that feels like it resides in the community and find an educational connection for it. You just have to think about it long enough, and you'll find most things have an educational meaning.
Mark, I'm going to jump in for 1 second. Something I learned that from you and brought it up at an IEP meeting once, and it was about chewing and swallowing. And I mentioned that need, and the district said, oh, no, that's medically based. We don't do that. And I said, oh, do you have snack time? And they said, yes. And I said, oh, but this child isn't able to participate safely in snack because of the chewing and swallowing difficulties, which prevents them from being with their peers. And that's how we linked it to academic. So an educational, it doesn't necessarily need to be academic, but it's what's happening in their everyday life within the school.
Exactly.
That's just a good example.
Choking hazards, child who's unable to eat or tolerate a range of textures or smells, and say they have a vomit reflex or a gag reflex. It's not very easy to make a friend if you're supposed to be making friends during snack time and you're gagging on your friend, that kind of thing. There's an excellent guideline I always like to tell my parents about. You can find it freely online, called the Guidelines for Occupational Therapy and Physical Therapy in the California Public Schools. It's a California Department of Education publication. You can search it freely online and it's available for download. And in that particular manual, there are these breakout pages that deal with OT in the classroom, PT in the classroom, And then you have this confounding question of where does feeding and chewing and swallowing end with a speech pathologist and start with an OT, or vice versa? Because what no one really explains to the families as they're navigating this process is that speech language pathology and OT have had this arm wrestling match, and they've decided they're going to split the process up at basically, where does it end for the OT, Justine? Isn't it at the swallowing mechanism?
Well, in California, the OTs do chewing and swallowing, and most other states it's speech pathologists. So
yeah.
Yeah. But and Mark, someone was just asking if you could say the name of it again. I'll type it into the group chat. What was the name of that document?
Guidelines for Occupational Therapy and Physical Therapy in California Public Schools. Also, if you're looking at the speech swing on things, you can always go to the American Speech and Hearing Association. There's a series of white papers. It's called ASHA.org. Those white papers deal with things associated with all things speech and language and audiology. So these are opportunities for you to study if your child has a particular area of need and to become proficient enough to ask questions. And I would say this happens quite a lot. Pardon the aside for a minute, but I think it's really important. Sometimes parents are in a meeting and they're asking a question, and maybe the question isn't framed properly, or maybe it isn't fully up to the level it should be based on the expert who's sitting across the table who knows all about that. They have a master's, they've studied it, maybe beyond. And maybe the parent feels like they're being told, hey, you know, that's not appropriate for schools, or that's not an appropriate question for the IEP team. It's really hard on parents, because at that moment you feel like you're kind of being shut down. And it doesn't happen all the time, but it does happen. What I would recommend, if something like that occurs, you could very quickly say, I appreciate it if this question that I have or concern that I have is not appropriate for this context, but I understand the reason that you're here as the OT is to help me formulate my concern into the mode that is appropriate for this process. So given the concern that I've shared, what would be the appropriate way to put this into the IEP doc? And then if you do it like that, you're now empowering that person who was somewhat rude to now become, you've co-opted them now to help you to get your concern into the document. Because at the end of the day, you've taken them out of this sort of adversarial feeling and you put them into team child again, which is like, let's us work together to fix it. But keep in mind, there's a very common principle in all special education. Every member of the team is an equal participant. If at any point your participation is diminished through a lack of information or a manner in which you're being treated, you simply have to say, I understand that this process is really geared around every member of the team is equal. And in the same way I'm showing in respect to the team members, I would also want my concerns to be respected and my participation to be genuine and meaningful. And there's not a whole lot anyone can say to that, except maybe, okay, well, let's work together and get it fixed. I would also want you to think about this very last prong, and then we'll move on. Is the program calculated to change with the child? What I talk about there is if you're looking at an annual goal, you might want to add some prompting on the front end of the goal, and then slowly move that child towards independent skill demonstration. And then next year, when you may be looking to expand the skill or go to the next level, you reintroduce the prompting again. And in this way, you sort of scaffold the success and look towards ensuring that the skills are independently acquired. It may not be possible. Sometimes you're going to need multiple years to get to independence, but strive wherever you can to quantify how you're going to fade the support so the child is going to get there and be able to demonstrate independent skill demonstration. Okay, let's jump on to the next thing. Okay.
Yeah. Okay, let's continue.
Okay, so you're basically in the offer of FAPE, it's going to be a combination of placement and services, and then we'll go into the specific tools that we suggest. Placement.
We've kind of already spoken about services as they relate to helping your student progress towards their goals, but this slide just outlines some kind of questions to consider in terms of, you know, if an offer is 30 minutes of language and speech therapy, there's so many questions that come with that. What goals are we working on? Is it one-to-one? Is the child being pulled out in the class? Is it consultation with the teacher? If it's group, if it's group speech and language, is that, and Justine, you're the professional in that end, so I'll defer to you, but I always think of like, are we working on social skills? Is that why we're in a group setting? Or, yeah, that's basically what I was thinking on those ends. Are the services appropriately tailored? Offering a set number of service minutes per week is great, but we want to make sure they're being appropriately used, right? And they make sense. That goes to, and we spoke again about this earlier for least restrictive environment, clinic-based services, referencing outside of school, right? Does student need to be spending those minutes in the classroom with his peers learning, so much so that it might be best to have his speech and language therapy outside of school? These are all pieces and aspects, as much as the entire program is individualized, as is every component part.
There are so many factors to consider on this, and it could be as simple as how many kids are in that group. How far is the group education, the group setting going to be from the child's regular classroom? Is it going to be a combination of kids from that classroom? Is it going to be children from different parts of the grade levels with different needs? You have to keep in mind at the end of the day that the therapist who's working with your child has to individuate those sessions to a degree, but also make them harmonize with the other students and their needs. The appropriate personnel, it's the whole, do you know who's working with your child? Is that person a true speech pathologist? Are they a speech assistant? These are questions that you have to ask. You have to ask the team and to have a better understanding of. Do the person's professional qualifications enter into this process? We were talking a moment ago about feeding and swallowing. Sometimes if someone's going to be working on feeding related issues, do they have the appropriate training and background? Like OT has, for instance, an advanced qualification called an SWC. It's a feeding and swallowing specialization. So these are the questions that you would want to be able to ask, and you would ask other things like, who's debriefing after this? How are the parents going to be navigating this? Almost all of the service professionals that serve your children in the school setting have a professional and ethical guideline on parent communication, how they're supposed to be sharing the child's progress, that kind of thing. And I would say that, it's fair that the team works a lot together. They work, they team for, multidisciplinary approaches to educating kids. And so as a result, they become very comfortable with one another and they know, oh, this is a case for so-and-so and that kind of thing. But the parents don't know that. And so you would want to make sure that you're building in things like parent education, parent communication. And this has another side to it for the professionals who are grad students and getting ready to go out into the world. When the school system builds your caseload, there may be expectations you have professionally that you're going to be speaking with the parents or filling them in, et cetera. But I want to make sure that you're keeping track of the time that would be needed for you to be able to do that client consultation and feedback, because ethically you would be wanting to do that. And if you don't have enough clinical hours in your work week in order to be able to do that, chances are you're going to start having some of these essential elements fall through the cracks. It's just a human factor. I also say it's also helpful with the school system to know if it has enough people to do the job. And this is especially true now when we've got related service professionals virtually across the board, where we've got deficits in the number of professionals available out there to take these jobs. So I think it's really important that you accurately account for your time from a parent's perspective, know what your participations are going to look like with your child's team, and set that sort of mutually respecting expectation of this is what we need in order to be meaningfully participating in this process and also to contribute. Okay, let's go to the next one.
For the next two, we're still touching on service providers. I just want to,
Okay.
I
think we could probably go through these quickly, I think, because I want to make sure we're allowing questions. And we have about 15 minutes. What do you think? Should we?
We've touched on these, we're talking proper qualifications for those providers. We're talking what specific interventions are they using with research-based interventions. I feel like we see a lot for dyslexia, for example. What research has shown effective to help kids with dyslexia? These are questions you can ask your IEP team, your service providers. This is information you have a right and should have as an IEP team member and obviously participant in your student's life. It all, in my mind, comes back down to the information you have. Information is power in this sense, right? It only serves to make you a more informed member of the team. Whether or not you might need some extra support in interpreting that information, that's why it's a team, right? We all have our individual qualifications to those points. So this slide and the next, what interventions are being implemented, and the qualifications of those providers. Ask questions. I think that's a good place to start. Make sure it's individualized and it's tailored for your student. So with that, I'm going to jump to once you have the IEP document.
Abigail, I'm just going to jump in for 1 second to say, if you are working with a non-public agency or a private therapist, as Mark said, you do not have to sign the IEP document at the IEP. You can sign that you attended, and then you're not agreeing to everything at that time. You can bring that document back to your private provider that you have a strong relationship with and say, what do you think about these services? What do you think about what they're offering? Is it adequate? What would you change? And most of your providers would be happy to review that with you and give their feedback.
That's a really good point. I think, this is a process where you have the benefit of taking some time to really read the documents. In fact, I would strongly suggest that you read them. This is a majorly important aspect of your child's life, and it's really too important of a process to just very quickly sign off then and there without having read the document first. Just some really quick protections and advisements. IEP teams can be documents can be partially authorized. Sometimes we receive reports from parents that school administrator will tell them that they are not able to agree to parts of an IEP. They have to agree to all. And there's no such thing as you must agree to all. You can agree to component parts. I will say that there are some particular concerns associated with first IEPs, and that is, especially for 3-year-olds or those who are seeking initial evaluation for eligibility, until you agree to some substantive element of the program, school district is not obligated to begin rolling out special education because they haven't been permitted to do so. So that first one, you just want to be cautious about, holding too long, because if your child needs the services, you have to authorize something, some aspect of those services. But if the program isn't right and you still have some work to do, be cautious of statements like, well, if you don't sign it, we can't move forward. That may be true, but it doesn't mean that the program that was in place before couldn't still be worked on. You can't unsign an IEP and go back to what you had. Once you sign an IEP, you sort of put that in effect and the old thing that was there goes away. So be cautious about advancing your IEP document with new authorizations that will replace the former ones if it's not quite right. There's the concept of stay put rights, and that is that there's a dispute between you and the district. The law says that once the parties file due process, you do have the right to ask the court to grant you stay put rights, which is the last agreed and implemented IEP that was in your child's program, could be put in place. Okay, let's go ahead and move forward. I want to get to questions, and I know that these next slides are important, but I also want to make sure that we're getting some representative questions.
I was going to say that 2 of them we've already covered. I can go on to, you want to touch on independent study, or we can move on to questions.
I think we can move on independent study.
We can have a follow-up, perhaps. Yeah.
Okay, let's see. How do the questions look?
I have some questions for you from Sonia. She said she has her son's IEP tomorrow, and she wants to know what the correct way to ask if the school can fund the IEE.
Well, if the IEE is being requested, the way that the law treats that is you have to disagree with the school district's assessment and request an independent educational evaluation at district expense. The school district can ask you why you disagree. I find that for many parents, it's a really tough position to be in because you're essentially being asked to sort of explain your concerns on the fly, and that's not very easy to do if you're not an expert in that domain. The law says you can be asked what the disagreement is, but you're not obligated to respond. And you can just say, I just don't feel comfortable going into it at this moment, but I'd be happy to get back to you and we can have a later discussion. Once the family requests an independent educational evaluation at district expense, the district either has to provide that without unreasonable delay or file due process. And the due process is for the purpose of proving the assessment is valid. And so I know that for some parents that feels maybe a little scary or intimidating. I think for the most part, if the school district is also struggling maybe to get some assessment data for the child, a lot of times that independent assessment can really help clear things up for everyone. And I think a lot of the school systems really want to work with the families. Now, on the other hand, if they're just very aggressively approaching the IE issue, you should know that you do have the right to step back from your request for an IE. And when you do that, parents don't have to go through the due process that the school district has to dismiss the case. So there are lots of twists and turns in the IE world. I will say at the end of the day, the goal is to really have the information you need to make the best decisions. Okay, other questions?
And just to mention about the IE, I did put in our RSVP list question or topics that people are interested in for future presentations. IEE was one of them. Okay. So Mark and I have spoken that we are happy to do that in the future. And I actually spoke with a colleague of ours who's a neuropsychologist who'd like to join that presentation. So be on the lookout for that. And then the other question I have is from Monica, who said, can you request that a specific strategy or intervention not be used based on child's prior experience with it?
Yeah, I think that, so let's clarify. The law is rather clear on this issue. The school district gets to pick methodology. However, the parents can raise concerns with the selection of the methodology, especially if the child has sort of an aversive response to that approach. And that really becomes an issue for negotiation between the district and the family and possibly a due process element. Congress said after IDA 2004 came into effect that research, that intervention should be research-based and peer-reviewed to the extent practicable. And so oftentimes a parent is struggling with an area of difficulty, and they aren't seeing their child progress, and they want to see something done differently. But that desire doesn't subsume the team's right to pick a program. The program still has to be subject to due process analysis, though. So if it really is something that parents raised their concerns, documented their concerns in writing after the fact, maybe shared some independent assessor's view on why it would be inappropriate, those would all be things the school district would have to take into account. You know, I didn't explain this cute little boy sitting here. That's my son, Andrew. If you can believe it, we took this photo of him back when we started doing some of this work. He's 23 now, much bigger than this, but I pop him in there because he's kind of the inspiration for all this work, 21 years or so at this point. So other questions?
Yes.
There was something I saw come across the chat. We'll definitely share the PowerPoint. This is information for your purposes. And I'll also try to do I'll gather some additional links to some of the other things we've talked about tonight so that you can find them easily.
Yes, and we're going to do our best to have it up on a YouTube channel as well. So I will send everyone a link to that. We have another question from Shantae, and I hope I'm pronouncing your name correctly. It says, my son was promoted from his assigned school district's preschool to the only designated elementary school within that district for TK this past May. After visiting the school he was assigned to, my husband and I felt extremely uncomfortable allowing him to attend. Since the school year started, he's been unenrolled. We are trying to enroll him in a different district once space is available. Is it possible to request an IEP without our son being enrolled, or do we have to use the existing IEP that was meant for the school we decided wasn't best for him?
Okay, this is an example. This is a good question, but there's some use of some words that I want to make sure that we're saying the same things. There's a lot of confusion around the concept of enrollment and attendance. And let's be clear, if you live in a school system that's offering your child special education, you've submitted your utility bills, your child lives in the district, you enroll your child. When you're enrolled, the school district has responsibilities to care for your child and to provide FAPE. Disenrollment doesn't only mean pulling your child out of school. That's no longer attending. Disenrollment is a technical term meaning you pull him out of school altogether. And when you do that, the school system is relieved of its obligations to serve your child. And that could include locating an appropriate TK program, let's say in the private school settings. So your child, let's say, needs general education exposure to TK. And maybe they need an aide to go along with them and be successful. And maybe that's all that's required. If you disenroll your child from the district, you're cutting yourself off from the support the school district might be able to provide, which could include services for speech, OT. It could include an aide to go with your child to the school. It could include placement in a private school. Those are all rights that could potentially exist for a family that maybe has a different view from what the school district sees. Now, there's some use of the words designated and the only one. And I would probably need more facts around those specific questions, because sometimes if school system says this is the only program we have, that may not be 100% accurate. That might be the only program that preschool feeds into according to their policies, but it may be that there are others in the district that could serve the child. Also, there are things like regionalized supports that we call them SELPAs, Special Education Local Planning Area in California. And these are gatherings of school districts where smaller school districts get together to share resources. Sometimes there's what's called a SELPA classroom. A SELPA classroom could provide services for children from a variety of districts who all could attend this one program that's located in another school district altogether. And it may be completely permissive. So I guess I get very nervous. I mean, I shudder when I hear the word disenroll, because it's true that you don't have compulsory education obligations until first grade. But for a child with IEP eligibility, we really should be providing comprehensive supports as young as 3, all the way until they graduate or no longer have the needs. But I get really worried about parents going it on their own to try to fund all of this through insurance or regional center and other things. There are so many traps associated with that approach. I would say probably step 1 is get some advice, especially with an attorney who's familiar with your region. And so they can walk you through, oh, have you considered this program, or have you considered this alternative? And, you know, we see the range of things out there. So there are lots of attorneys who have regional awareness and know what might be going on in that particular district. So I would take advice. Most lawyers will offer you a free consultation. I know we do. I don't charge for consultations here in the office. I always have seen it as a job interview for me. So I've never quite understood how attorneys charge for consults, but many do. But you can probably get a free consultation. Someone will sit down with you and your documents and help you understand what your rights might be.
Next question was, under what circumstances will the district refer out to speech therapy? So I can take that one.
Yeah, for sure.
And it is often if you've gone to due process and you are not happy with the services being provided at that district, if they do not have a therapist available to see the student, if they do not have a therapist who has a specialty, maybe your child has childhood apraxia of speech or something that requires specialty training, then they may refer out to a non-public agency. Did I miss anything, Mark?
I think that's correct. I would, I think you said it, but I mean, just to sort of underline it, intensity. Sometimes especially like things like childhood apraxia of speech, yes. We know that the frequency is really important, and also matching the children with other children with the same or similar needs, right? So if you're going to do it in a group, which is usually, as I'm sure you would tell us, probably not always encouraged to do unless it's the just right group.
Right. Yes.
I would say the concept of, in California, of non-public agency, non-public school, that's one of those terms that gets confused. It just means that that agency or that school has registered with the state of California to provide the services in special education in the private sector, and that school systems can contract with those agencies to provide the services so that they remain free, even if they are private, right? So yeah, there's a range of reasons why we would look to NPAs, therapist availability, just like you said, Justine, those are pretty
major
common grounds. Yeah,
reasons we get it.
Mm-hmm.
Okay, if your child is already in a private school, such as Frostig, is it still possible to get the public school to pay for parts of the support? My child went to a different school district than the one we live in, and we pulled him out and put him at Frostig. Is there any chance that we can still get our local school district to pay for any of his services?
Possibly. There's a few things there that technically have to be observed. First off, the question of enrollment, if you've left one school district and you've gone to a non-public school, Frostig is a school in Altadena that is a trusted partner of many professionals in the area. What I would say is that you have to start the analysis with enrollment in the district that should be serving your child, and then the other question is notice, which is in order, under the law, in order to seek reimbursement for placements outside of the school system, you have to provide the school district with notice of your intent to place in advance of placement. And the law is a little strict on that because oftentimes, it sounds like in this fact pattern, you're already there and you're wanting the local school system that's your home school district to help you. The best way, I think, to go about this process would be to enroll and then call for an IEP team meeting and invite your representatives from the private school to come to the meeting and talk about the child's unique needs. The school system may say, this is probably the right place for the child. Maybe we can get on board with helping you. And it just depends. You're going to run into different interpretations based on different school systems. Understandably, your local school system is going to want to try to serve the child with the resources that they've already built in their home district. But, it's kind of like, I sometimes explain it as sometimes it's like going into the shoe store and your size is 13 and they have a serviceable set of 8, 9, and 10. And it's like, well, thank you. You've really worked hard to build this, but none of them are the right fit for my child. And so it's okay. It's okay that we have our children are unique and they present differently, and not every program is perfect for every child. If everyone's talking about the child's unique needs, though, should be an opportunity for collaborative discussion. And if there's disagreement in that context, you have mechanisms. So I would say always, try not to lose your cool too much. The school system, I always say that, they dedicated their professional lives to helping children. Try to assume that they're there for the right reason. Try to give people the benefit of the doubt if you can. Can't always. Sometimes it's going to be really infuriating. But it's like any difficult process. I think you think more clearly and strategically when you're calm and organized, and you keep your eye on the ball. And I say in this case, keeping your eye on the ball is keeping the child in the center of the analysis and not letting those frustrations flare up and cloud your judgment. And break down the negotiations between the team.
Mark, I know it's 7:30. We have like 2 more questions. Are you okay to answer those?
Yeah, of course.
Okay.
Yeah, I know Abigail and I we're in it for the long haul.
Okay, thank you. And this is from Allison, who is one of my amazing therapists. And she says, does IEE extend to AAC devices? For example, if a student qualified for a device through their insurance, does the school district need to do their own assessment, or can the child's device be written into the accommodations section?
So AAC or AT is a related service, which is the way that the law describes assistive technology or augmentative alternative communication device is any device, whether high tech or low tech, either acquired off the shelf or custom, that's created to help the child access their education. And that could be for learning supports, it could be for communication. If the parents have secured an insurance assessment and the school district says, you know what, it's a great assessment, we accept it, and we're going to provide the service, it could be done. I do think, as a general rule, most school districts will want to do their own testing before they commit to providing services, only because I think that's just the way it's done. With very rare exceptions, school districts will almost always do their own testing. They'll consider the outside assessments, but I don't know that they'll necessarily adopt them. There's one exception to that. California law has a carve out for 0 to 3 transitions, and sometimes time is tight, and the school system can't organize in time to get the assessments done. And there are provisions where the school system can adopt the regional center assessments as a basic premise for what the child needs, and that's done that way. But AT and AAC in particular, these are related services, like the San Diego case talks about, any service that helps a child access their goals. And the provisions of assistive technology are delineated in the law, federal law, California law, and also, many people don't know this, but regional centers in California also have provisions associated with assistive tech. And so there is a third possibility there, which is to go to, after the insurance, after the school system, to your local regional center. This is becoming one of those areas that is taken up more so, especially in this age of self-determination, where more and more families are looking to take control of their programs and roll out things that really work for their children. Don't forget about AT in that.
Thank you for that. Okay. Can the district deny support services or recommendations from IEE assessors if we pull our child in kinder for half of the school day to attend behavior therapy outside the school?
Well, kinder is a funny time because it's, like I was mentioning before, compulsory education starts at 1st grade. And so kindergarten is really, even though, I mean, everyone goes to it, but it's generally considered elective under the code. I think the parents exercise a degree of flexibility with how they want to roll things out for their children in non-compulsory school years. I think the concern that comes up there is, I think that the family probably needs behavioral supports after school already. And there may be questions about maybe the child's energy levels or how much can they do in a single day. And there are maybe reasons that the family wants to take portions of the school day and work on behavior. What I would have pause if the question is, we have to pull our child out because we need behavioral supports and the school system just isn't helping us. Because I think that raises a whole other slate of concerns. If the school system and the parents don't see eye to eye, and the parents are resorting to insurance or regional center for behavior supports, there's a common concern associated in particular with behavior, but I think it applies to many other disciplines. And that is the concept of generalization of required skills across settings. And it stands for the idea that when a child truly has acquired skills and a service is being rendered with fidelity, that your child should be able to consistently demonstrate the skill across different settings: school, home, in the community. And it's said that a skill is not truly onboarded until it's generalized and able to be shown everywhere. That's when the child can do the things that we're hoping they can do. When you are speaking about behavior, there are concepts of common language and common approach, which is, especially if we talk about children on the autism spectrum or children with receptive language difficulties. In general, I get concerned if we're giving them prompts that feel very unique and different for them, meaning the school system prompts them one way, the home therapist prompts them another behavioral way, the parents have another set of language. We may be saying the same thing 3 different ways to the child and expecting the child to sort of navigate all of our communication efforts. Also, keep in mind things like latency, which is sometimes it takes children time to process an instruction. And so can you imagine the situation where the school-based behavior team is giving the student instructions, maybe not necessarily giving time for the child to process what's being asked before the natural human instinct is to go ahead and say the next instruction or say it a different way, as if somehow the first way that it was said, the person didn't understand and they needed it simplified or clarified. For children who are exhibiting latency concerns, they're processing the first instruction, trying to work through that, and then the second one comes, and immediately, what does that do to the first instruction? It gets kind of lost. Can you imagine if you're doing that in different ways, in different manners, in different places, home, school, community, and the parents, and then the child who has a disability that essentially is born out of communication deficits and concerns? It's a recipe for total disaster. So I would suggest, and again, sometimes I hear facts and they speak to certain concepts that Abigail and I see in the daily. But I think it's really important that everybody be speaking the same language for the child. And I don't mean like Spanish, English, so forth. I'm talking about the cueing should be consistent. Okay. Justine, you're muted on your side.
I made it through almost the whole thing without doing that. 2 more questions. One was just a comment, which I thought was a good one to say that you are allowed to record your IEP meetings, but just something to know that you do have to let the district know. Is it 24 hours in advance that you're going to be recording them?
In California, I think other
okay.
states may have different rules, but
Okay.
in California, it's 24 hours advance notice.
Okay.
I would recommend doing it in writing. I've had situations where families notify, but then someone later says, well, we didn't receive that message. And then it's a very uncomfortable scenario. So I usually will send a fax, or email's less reliable because you can prove that it was received always.
Okay. 2 more questions and then we're going to end there. It says, last year's special needs program no longer exists as it was moved to a different school administration. From our parent-teacher conference, we discovered that our child's grades and ability to attend to activities don't align with the last year's grades or IEP. We were also made aware from his one-to-one aide that the previous teacher would accept grades based on skills reported from home and did not make any attempts to assess the same skills in the classroom. What recourse do we have for the new teacher and new special needs program?
Wow. That's a lot of moving parts. I'm sorry that happened because it sounds like you were fully invested in the feeder program, and then to have the rug pulled out to a degree, it's really hard for you from an informed participant perspective, and I think probably hard for the recipient teacher as well. Which is, can you imagine a whole group of kids coming that have a totally different set of preparation? I think what I would do with a situation like that is, of course, I would start foundationally with what is known about the child's unique needs. If there's a concern that maybe what the child is able to do isn't necessarily being accurately reported, and the new teacher is going to have their hands full. So you might want to call for assessments. The other thing you should be aware of is most school systems and in the field of education, it's understood that there's a certain degree of a honeymoon period, which is usually the first 30 to 60 days are a time period when the new teacher is sort of going back over review material to see where the children are and getting them prepared to launch into that year's curriculum. But I think I wouldn't lose hope in this situation. I would go back to what are the California standards or the standards in your jurisdiction call for. I would do a summary of skills. I would link those skills with the California or the standards expectation and see where the areas of need are that the child is currently functioning and where they need to be. There are different tools that are available for children based on the age. Like for instance, if this were a preschool, TK, kindergarten transition concern, I would have one set of instruments I might recommend. If this were a middle school to high school concern, so I guess what I would suggest is that understand you have a complex problem. You probably need some professional guidance and advice to understand where your child is currently performing, what they need help with, and then to build the program. And so err on the side of information and get some guidance.
All right, the last question. If my child has transportation written as home to school, school to home in her IEP, and the school is recommending she take a community college class, dual enrollment, does the school need to cover transportation from school to community college and home, or is this case by case?
If the service is written into the IEP as curb to curb, which is what you're describing, then the child would be entitled to transportation. If it's not written in the IEP and it's something you feel your child requires, then the manner in which you would go about that would be to analyze the child's unique needs and then devise a FAPE that addresses those unique needs. Transportation training is something that we traditionally would want to see on board for a child in the IEP that is in place when they turn 16. It's one of the basic transition supports that is needed. And so if for whatever reason that window has passed you by and you now find yourself post K through 12 and now into college, or maybe you're in some college classes while you're in 12th grade or something like that, then I think you have to start with the essential question, which is the child able to individually, independently get from here to there safely? I think it has to be more than they don't have a car and it's inconvenient. I think it has to be more like, what is the unique educational need they have that would require the support? But in this case, the facts you're giving me suggest that it's already written in. So we'll just say, well, here it is. It's right there. So let's work on that.
We made it through all the questions. And if there are any more, please feel free to reach out to Mark directly. You can also email me. You should have received emails from me with the Zoom link, so you have my address, and I can always pass them on to Mark. Or if they're regarding speech and language or educational therapy, I'd be happy to answer them as best I can as well. So we are going to do our best to edit this and get it up onto YouTube so you're able to view it as soon as possible. And we will be sending out information for future presentations regarding IEE or transition from regional center into school district services or early intervention into school district services. And another request was goal writing for IEPs and also the parent's role in therapy. So those are all great options for future presentations.
I really appreciate the opportunity. I know that especially these days, doing this via Zoom has really become, an opportunity for people to join where maybe in the past, because of care needs or other things, we really couldn't join. But, Justine, on behalf of all of us, thank you for helping to provide the platform. And, to the parent community, I would just say, keep at it. I meet parents and work with parents every single day. You are a resilient group and you're doing the right thing. But keep the child in the center of the analysis and be collaborative and courteous, but insistent and confirm. I think that's what any serious person would be expected to do in this setting. But your child is there and they're ready to learn, and they want to rise to the level that they can. And I want to make sure that if they're not getting there as fast as we'd all love them to get there, I want it to be because their unique individual development says they need more time, not because the services that if they had received them, they would have been able to make the progress. So stay strong, stay in this, and keep it up. You're doing great. And we'd love to hear from you, your feedback, suggestions for how we could make this better. And we'll always try to be responsive. I appreciate you, Justine, and your team, and my colleague Abigail joining me today. It was really nice of her to put in the extra hours today for parent support and pro bono activities.
Yes, thank you, Abigail. It's just, I welcomed her to our presentation gang. So now it's the three of us.
Happy to be here. Yes.
Excellent. Well, thank you, everyone. We hope you have a great night. Good luck with any upcoming IEPs, and please reach out in the future.
See you.
Bye.